Ladies and gentlemen, brothers and sisters, friends and music comrades, let's watch what's happening as this pertains to the Gachagua's impeachment process.
Of Rigathi Gachagua was unconstitutional. Therefore, he's still the Deputy President of the Republic of Kenya. How do you deal with such an ugly situation? That is one of the things that the court really has to critically analyze in a constitutional quandary. Yes.
So there will be political considerations as they decide which way to go with the conservatory orders.
There was consider politicians not swayed by political or political persuasions, but in a vacuum. I think that's why one of the critical canons of constitutional interpretation is what we call contextual interpretation, and as well as consideration of what they call, and in fact the High Court did mention it, considering non-legal phenomena. So that, of course, the Constitution is purely a legal document, but the non-legal phenomena is this. You need to settle this controversy of who really is the Deputy President of the Republic of Kenya. Remember, there are
Oh, this shit is not working. Uh, Sorry, ladies and gentlemen, brothers and sisters. I'm having technical problems here.
a typical impeachment regime, the jurisdiction is purely that of the National Assembly and the Senate. And in my view, the process ends there. The political process of impeachment. In the vacancy, read clearly in the language of the Constitution, and I think this is a contextual reading, perhaps non-legal reading of the Constitution. The regime is that of the national vacancy and of the president. So in my view, I do not think that it is accurate that one can invoke the jurisdiction of the Supreme Court to challenge the nomination of a person to fill the vacancy of the presidency. Two different constitutional imperatives that should be given context whenever one is interpreting a controversy or applying the Constitution when a controversy of this nature arises.
All right, Wakili, I am informed that the judges have made their way into the courtroom. Let's head straight to the Milimani.
We are having technical problems. We are going to get it fixed as soon as possible.
My name is.
Why is this thing?
This is the rule that we have given the introduction, we have given the background,
consolidated petitions. The first preliminary issue that was raised before us is the jurisdiction of this bench. While it was also argued that the court has already determined this matter, rendering it res judicata, we believe it is necessary to revisit the issue due to the new arguments that have emerged during submissions and in light of the unprecedented nature of the case before us. We find it prudent to further clarify our jurisdiction so as to ensure that the issue receives the comprehensive and careful consideration that it deserves. In determining this preliminary issue, we are reminded of the authoritative words of Nyarangi J.A. in the widely celebrated case of owners of the motor vessel Lillian S. versus Caltex Oil Kenya Limited, reminding us that without jurisdiction, a court has no power and must down its tools in respect of the matter in question. This principle has since been reaffirmed in numerous landmark decisions by the Supreme Court, underscoring its centrality to the exercise of judicial authority. In the case of Machari and another versus Kenya Commercial Bank Limited, the Supreme Court was unequivocal in its holding that a court's jurisdiction flows from either the Constitution or legislation or both. Thus, a court of law can only exercise jurisdiction as conferred by the Constitution or other written law. It is quite a lengthy paragraph there. However, let me also say the Supreme Court stated that where the Constitution exhaustively provides for the jurisdiction of a court of law, the court must operate within the constitutional limits. It cannot expand its jurisdiction through judicial craft or innovation. And the quotation goes on. Likewise, in Adenga and two others versus Kibos Distillers Limited and 5 others, the Supreme Court again emphasized as follows: a court, even this court, that is the Supreme Court, cannot arrogate itself jurisdiction through crafts of interpretation, and a court ought to exercise its powers strictly within jurisdictional limits. End of quote. We find it necessary to address the issue of jurisdiction by examining the historical context of Kenya's constitutional drafting process, as highlighted by learned counsel Dr. Thiankolu in his submissions. Counsel presented the court with excerpts from earlier drafts of the Constitution, tracing the evolution that led to the promulgation of the 2010 Constitution. Notably, in all these earlier drafts, express jurisdiction was conferred on the Supreme Court to hear and determine disputes arising from the impeachment process. However, in the final promulgated 2010 Constitution, this specific provision was deliberately omitted. Based on this historical backdrop, counsel submits that even if this court were to find that this dispute is justiciable, a matter which we will address in the second preliminary issue, jurisdiction should lie with the Supreme Court and not with this court. We have carefully considered this argument, which the petitioners opposed. Article 2(1) of the Constitution is unequivocal that no person or state organ is above the Constitution. It further affirms that all state authority must be exercised in strict conformity with constitutional provisions. By virtue of Article 2(4), any act or omission that violates the Constitution is both unlawful and invalid. This establishes a clear basis on which the actions and omissions of all state organs must be scrutinized for their constitutionality. The bone of contention before us is whether that jurisdiction ought to be exercised by this court or by the Supreme Court. As we have already noted, the final version of the 2010 Constitution marks a clear departure from previous constitutional texts regarding the jurisdiction of the Supreme Court. Specifically, the provision granting the Supreme Court exclusive and original jurisdiction over disputes arising from the impeachment of the president, that bit was deliberately omitted. The Supreme Court's jurisdiction is now strictly redefined under Article 163, sub-Article 3. This leads us to the firm conclusion that the people of Kenya did not intend to grant such jurisdiction to the Supreme Court. Had that been the intention, the Constitution would have expressly conferred this authority in its final form. The Supreme Court has itself acknowledged that its original jurisdiction as outlined in the Constitution is exhaustive. This implies that any attempt to expand its jurisdiction beyond what is expressly provided for would contradict the Constitution's intent. Again, we refer to the case of Machari and another versus Kenya Commercial Bank, in which the Supreme Court itself stated as such. Article 163 of the Constitution provides for the jurisdiction of the Supreme Court in exhaustive terms, though leaving room for Parliament to prescribe further appellate jurisdiction in terms of Article 163, 3b2, which stipulates that the Supreme Court shall have appellate jurisdiction to hear and determine appeals from any other court or tribunal as prescribed by national legislation. The Supreme Court goes on to note that the Constitution also confers jurisdiction upon the Supreme Court to hear and determine an appeal from a judge who has been recommended for removal under Article 168(8). As far as we are aware, Parliament has yet to confer any further appellate jurisdiction upon the Supreme Court in terms of Article 163, 3b, Roman 2 above. Even with regard to the special jurisdiction previously conferred by Section 14 of the Supreme Court Act, which was repealed by Section 15 of Act number 26 of 2022, the Supreme Court was unequivocal in again affirming that this provision did not grant Parliament the authority to expand the court's jurisdiction beyond what is contemplated in the Constitution. The court expressed this position. Again, we go back to the case of Machari and another versus Kenya Commercial Bank and two others. It's important to read the text. The Supreme Court states as follows: what is the proper province of Article 163(9) of the Constitution? Does the article contemplate a situation where Parliament can confer further jurisdiction upon the Supreme Court? We hold that it doesn't. The act contemplated by Article 163(9) is operational in nature. Such an act was intended to augment the rules made by the Supreme Court for the purpose of regulating the exercise of its jurisdiction. It is an act that must confine itself to the administrative aspects of the court. It is a law that addresses the manner in which the Supreme Court exercises its jurisdiction as conferred by the Constitution or any other legislation. And they go on to summarize, such an act was never intended to create and confer jurisdiction upon the Supreme Court beyond the limits set by the Constitution. From this analysis, we have come to the conclusion that the jurisdiction to hear disputes arising from impeachment of the President and Deputy President does not lie with the Supreme Court within the realm of original and exclusive jurisdiction. Instead, such jurisdiction may be exercisable within the Supreme Court's appellate jurisdiction. We now turn to the jurisdiction conferred on the High Court under Article 165(3) of the Constitution. Notably, the High Court is also vested with a broad scope of original and somewhat residual jurisdiction under Article 165(5), which grants this court jurisdiction over all matters except those explicitly reserved for the Supreme Court or for courts of equal status. This broad jurisdiction demonstrates a deliberate intention by the drafters of the 2010 Constitution to empower the High Court to address matters not expressly covered in the Constitution, ensuring that no legal issues, including, as what is before us, impeachment proceedings, fall outside the court's purview. By vesting the High Court with such extensive authority, the Constitution also guarantees that gaps in constitutional coverage are filled, allowing the court to adjudicate on significant issues that may arise within the evolving landscape of governance. Within this framework, the jurisdiction conferred under Article 165(3) extends to adjudicating any alleged infringement of the Bill of Rights and interpreting the Constitution. In this context, Article 165(3)(d) Roman 2 expressly grants the High Court the authority to determine whether any act purporting to have been done under the authority of the Constitution or any law is inconsistent with or in contravention of the Constitution. This reinforces the High Court's pivotal role as the guardian of constitutional integrity, ensuring that all actions by state organs or individuals are in full compliance with constitutional dictates. A closer examination of the Constitution confirms that the drafters expressly intended to exclude the High Court from hearing appeals related to tribunals established under Article 144. Given this explicit exclusion, and against the foregoing discussion, if the drafters had similarly intended to bar the High Court from determining disputes under Article 145, they would have done so with equal clarity. Nothing would have been simpler, in our view, than to expressly exclude such jurisdiction in the same manner. The absence of such an exclusion with respect to Article 145 strongly suggests to us that the drafters intended for the High Court to retain jurisdiction over such impeachment matters. This approach to interpretation, whereby jurisdiction is said to be unlimited in the absence of any explicit limitation, is supported by the Supreme Court in their decision in the case of R versus Karisa Chengo. The Supreme Court noted as follows, we quote, "The limits of this authority are imposed by the statutes, charter, or commission under which the court is constituted and may be extended or restricted by like means." We emphasize that if no restriction or limit is imposed, the jurisdiction is said to be unlimited. The quotation goes further, but that is the emphasis statement. It is undisputed that the impeachment of the Deputy President is a constitutional process outlined in Article 145 of the Constitution. The authority to determine whether the merits and procedures of such an impeachment process align with constitutional requirements, therefore falls squarely within the jurisdiction of the High Court as provided for under Article 165(3)(2). The role of the courts in an impeachment process was reiterated by the Supreme Court in the case of Sonko versus Clark County Assembly of Nairobi. That is another quotation that we have reproduced in our ruling when you get to read it. The court went on to state that the impeachment architecture in the Constitution, the law, and the standing orders leaves no doubt that removal of a governor relates to accountability, political governance, and personal responsibility, and not necessarily about criminal responsibility. It follows that insofar as the process of removal of a governor from office is concerned, the court's role is confined to deciding whether the governor's constitutional rights and fundamental freedoms have been breached in the process and whether the procedures for removal from office have been followed without the court constituting itself into any of the two constitutional organs in whose hands the power to remove is vested. While we acknowledge that this referenced decision pertains to the impeachment of a governor, we maintain that the same constitutional principles apply to the impeachment of a deputy president. And accordingly, we do hereby find and hold that this court has the jurisdiction to sit and determine the matter that is before it.
The second issue is whether the matters raised in the consolidated petitions are justiciable. Ordinarily, an application for conservatory orders concerning the subject matter of a suit is relatively straightforward, as the law in this area is well established. However, the current applications before the court are far from routine. These applications are imbued with political maneuvering between the applicants and the respondents. In essence, power struggles involving other constitutional organs have been brought before this court for a legal solution. As a result, this court has become the stage upon which political excesses are to be examined and resolved. Inevitably, such cases evoke intense emotions. The impeachment case of the first petitioner currently before this court exemplifies the dilemma faced by the judiciary when handling cases that straddle the line between legal and political domains. There is no doubt that many are watching to see how the court will navigate this delicate issue, one that has significant implications for the doctrine of separation of powers among the three arms of government. Answering this issue requires a brief analysis of the doctrine of separation of powers in relation to the doctrine of justiciability. French political philosopher Montesquieu first formulated the doctrine of separation of powers through his seminal work, L'Esprit de Louis, in other words called the Spirit of Laws, which was published in 1748. Montesquieu argued that such separation limits the possibility of arbitrary excesses by the government, since the sanction of all three branches is required for the making, executing, and administering of laws. The Constitution of Kenya 2010 clearly delineates the three arms of government, each with its own distinct personnel and roles, as set out under chapters 8, 9, and 10. Chapter 8 establishes the legislature and details its composition, functions, and powers as the law-making body of the government. Chapter 9 outlines the structure, the functions of the executive, whose primary role is implementing and enforcing laws and policies. Chapter 10 focuses on the judiciary. It defines the structure of the courts and lays out the judiciary's mandate as the arbiter of disputes and the guardian of the Constitution, tasked with interpreting and applying the law impartially. While the provisions regarding judicial power under Chapter 10 of the Constitution are clearly defined, the political question doctrine, also referred to as the non-justiciability doctrine, highlights the limitations on the judiciary's role in adjudicating matters that fall within the purview of other branches of government. This doctrine essentially asserts that certain issues are not suitable for judicial determination because they are better addressed by the legislative or executive branches, which have the constitutional mandate and expertise to handle them. Black's Law Dictionary, 10th edition, at page 943 to page 944, defines justiciability as a matter that is, in quote, proper to be examined in courts of justice, or a question as may properly come before a tribunal for decision, close quote. There is an abundance of judicial pronouncements expounding on the doctrine of the political question. For instance, in Marbury versus Madison, Chief Justice John Marshall established the principle that while the courts have the authority to interpret the law, certain political questions are outside the scope of judicial review. The case underscored that where the Constitution assigns duties to other branches of government and does not provide standards for the judiciary to assess those duties, the matter is deemed as non-justiciable. Closer home, in William Odhiambo Ramogi and two others, as Attorney General, a five-judge bench observed as follows. The justiciability doctrine is rooted in both constitutional and prudential considerations and evinces respect for the separation of powers, including a properly limited role of the courts in a democratic society. One justiciability concept is the political question doctrine, according to which courts should not adjudicate certain controversies because their resolution is more proper within the political branches. In Baker versus Carr, the United States Supreme Court outlined 6 matters that could present political questions as follows. 1, a textually demonstrable constitutional commitment of the issue to a coordinate political department. Or 2, a lack of judicially discoverable and manageable standards for resolving it. And 3, the impossibility of deciding without an initial policy determination of a kind clearly for non-judicial discretion. 4, the impossibility of a court's undertaking independent resolution without expressing lack of the respect due to coordinate branches of government. And finally, an unusual need for questioning adherence to a political decision already made and the potentially of embarrassment from multifarious pronouncements by various departments on one issue. Additionally, the Court of Appeal in Kenya Airports Authority versus Mitubel had this to say: with this in mind, the role of the legislature is to make laws and policy, and that of the executive is to implement those laws and policies. The role of the judiciary is to interpret the policies and laws as enacted and approved by the legislature and the executive. Generally, courts have no role to play in policy formulations. Formulation of government policy is a function best suited for the executive and legislature, close quote. In Kiriro versus Ngugi, a 3-judge bench had this to say: a court must satisfy itself that the case before it is not caught up by the bar of non-justiciability. The concept of non-justiciability is comprised of 3 doctrines. Firstly, the political question doctrine. Secondly, the constitutional avoidance doctrine. And thirdly, the ripeness doctrine. The doctrines are cross-cutting and closely intertwined. We shall, however, endeavor to, as far as possible, delimit the operation of each doctrine in isolation, close quote. This bench starts with determining whether the issue of the impeachment of the deputy president falls within the category of cases where the concept of non-justiciability would prevent this court from hearing and deciding the matter. The essence of this question lies in assessing whether the political question doctrine would apply, thereby barring the court from intervening in what might be considered a matter reserved for legislative or executive branches under the Constitution. Learned counsel Dr. Thiankolu relied on the U.S. decision in Nixon versus United States to argue the case that the dispute before the court is a political question and hence non-justiciable. We have given due consideration to this decision, noting that it pertained to a dispute involving the impeachment of a Chief Justice of a federal district court in the United States. In resolving the matter, the district court held that it lacked jurisdiction to hear an appeal from the Senate regarding the impeachment of the chief judge, deeming the claim non-justiciable. In determining whether a dispute is non-justiciable, the court held that the test depends on whether, in quote, there is a textually demonstrable constitutional commitment of the issue to a coordinate political department or a lack of judicially discoverable and manageable standards for resolving it. The question to ask, in simple terms, is whether the 2010 Constitution specifically assigns the sole responsibility for resolving disputes arising from the impeachment of the Deputy President, as in our case, to another branch of government. Additionally, are there clear legal rules or standards that a court can apply to reach a fair and just decision on such matters? Within the context of the American system, and as articulated by the court, the learned judges answered the first question in the affirmative. They held that Article 1, Section 3, Clause 6 of the U.S. Constitution demonstrates a clear textual commitment of the impeachment process to the Senate. For clarity, this clause, known as the Impeachment Trial Clause, states, in quote, the Senate shall have the sole power to try all impeachments, close quote. We previously referenced the pre-2010 Constitution drafts that were brought to our attention by Dr. Tiankolu. What is evident from this text is that the people of Kenya clearly intended for the impeachment process to be a justiciable matter. This conclusion is supported by the fact that each constitutional draft contained provisions affirming this intent. This position is unsurprising when considering the historical context in which the Constitution was created. The people of Kenya sought to move beyond a past where the judiciary was often marginalized or bypassed in efforts to check governmental excesses. Instead, they envisioned a new constitutional order in which all branches of government would be held accountable and subject to comprehensive constitutional oversight. This aspiration was central to establishing a balanced system that ensured no arm of government operated beyond scrutiny. We are therefore not convinced, against a holistic reading of our Constitution, that there was any intention to deliberately place the impeachment power on the legislature with no judicial involvement. To hold otherwise would be to create an absurdity whereby the dictates of the Constitution under Articles 23, 160, and 165, 3D2 would be defeated. In our view, this decision is further distinguishable by the fact that the appointment of judges in the United States and Kenya differs significantly due to unique political structures and systems of government. Judicial appointments in the US are more overtly political, with the President and Senate playing direct roles. In contrast, Kenya's system emphasizes judicial oversight through the Judicial Service Commission, which is designed to limit political influence and promote greater judicial independence. Going back to the question that we posed previously, it is clear that unlike the US position, there is no textually demonstrable constitutional commitment of the issue of impeachment solely to any political department or institution. Drawing analogies, the fact that the American context states that the Senate sits to solely try impeachment disputes is a major departure from the 2010 Constitution. Even though the requirements for the two-thirds vote and the taking of an oath are identical, the procedure and provisions of the Constitution, as we have spelled out, leave no doubt that the Senate is not the sole determinant of the dispute. We have already expressed ourselves succinctly on the jurisdiction that has been conferred to this court under the Constitution in our previous decisions. It is now well settled that there are instances in which the courts will and should interfere with political processes. A few decisions suffice to demonstrate this position. The Court of Appeal in Martin Nyaga Wambora and 3 others stated as follows at paragraph 62. The political question doctrine and the concept of separation of powers cannot oust the jurisdiction of courts to interpret the Constitution or to determine the question if anything said to be done under the authority of the Constitution or law is consistent with or in contravention of the Constitution as per Article 165, sub-Article 3D2. Equally, as we have seen in the case of William Odhiambo Ramogi, the court stated that there are constitutionally permissible situations where this court may interfere in the policy decisions of the government, and particularly if a policy decision is in equal or in actual or threatened violation of the fundamental rights guaranteed under the Constitution or in violation of other provisions of the Constitution. The necessity of vindicating constitutionally secured personal liberties and fundamental freedoms is the principal justification for the anti-majoritarian power that judicial review confers upon the courts, and we are therefore reluctant to find that a claim of fundamental rights, such as the one presented by the petitioner, is non-justiciable, even though it may concern the political process or the internal workings of other government branches. Close quote. The crux of the petitioner's case centers on key questions, including whether the process was followed by the National Assembly and the Senate in the impeachment of the first petitioner, and whether the first petitioner was afforded sufficient time to prepare his defense against the impeachment charges. These issues strike at the heart of constitutional and procedural fairness, raising concerns about the extent to which legislative bodies adhered to the standards of due process as outlined in the Constitution. The petitioners contend that the impeachment process must align with the constitutional principles of fairness and justice, ensuring that any office holder facing such proceedings is provided with a reasonable opportunity to respond and defend against the charges. This court is therefore called upon to examine whether the procedural safeguards required by the Constitution were observed during the impeachment process, and whether any potential lapses could render the process flawed or unconstitutional. Such an inquiry will involve a careful review of the actions taken by the National Assembly and the Senate to determine if the principles of due process and fair administrative action were upheld. We take the view that, based on a holistic reading of the 2010 Constitution, the political question doctrine cannot oust this court jurisdiction as granted under Article 165, sub-Article 3. Article 165, sub-Article 3 confers upon the High Court the authority to hear and determine questions regarding the interpretation of the Constitution and the legality of any acts or omissions by state organs. This provision underscores the High Court's critical role in ensuring constitutional compliance, even in politically charged matters. The Supreme Court of Kenya in Sonko case supports this position in its holding that impeachment proceedings are inherently political. They do not fall beyond the scope of judicial review. The court stated as follows. It's a fairly long quote, I've given it. In Martin Nyaga Wambora versus Speaker of the Senate, the Court of Appeal also held that judicial intervention in impeachment must be exercised cautiously. While conservatory orders may be issued to protect constitutional rights, they should not encroach upon the legislative process unless clear evidence of constitutional or procedural violations exists. The court underscored that judicial intervention should respect the separation of powers, ensuring that the judiciary does not undermine the functions of elected bodies. South African courts have similarly addressed the scope of judicial intervention in impeachment process, emphasizing the balance between constitutional oversight and respect for the separation of powers. A notable example is Economic Freedom Fighters versus Speaker of the National Assembly and others. This is a 2018 matter, which involved impeachment proceedings against former President Jacob Zuma. In this case, the Constitutional Court affirmed that while the judiciary has the authority to ensure that impeachment proceedings comply with constitutional requirements, it must exercise restraint to avoid encroaching on the disciplinary functions of the legislature. The court made it clear that judicial intervention is warranted only when necessary to correct political procedural irregularities or constitutional violations. The ruling highlighted that conservatory orders should be applied with caution to prevent unwarranted intrusion into the legislature's domain. The court had this to say, quote, "Courts must be careful not to impose themselves in a matter that disrupts the legislative process or undermines the authority of Parliament. Judicial oversight is essential to safeguard constitutional rights and ensure procedural fairness, but it should not extend to directing how the legislature carries out its internal disciplinary proceedings unless there's clear evidence of procedural defects or breaches of the Constitution." This decision underlines the principle that the judiciary's role in impeachment matters is not to take over legislative functions, but to ensure that such processes are conducted in a manner that respects constitutional norms and procedural fairness. It reinforces the idea that while the doctrine of separation of powers is crucial, it does not preclude judicial oversight when fundamental constitutional principles are at risk. It is therefore our finding, based on the above, that the Constitution of Kenya has clearly delineated independent and distinct paths for the three arms of government. Accordingly, this court's intervention in the matter before it is warranted through a very narrow window that allows for oversight in cases where constitutional infractions are alleged in the impeachment process. This position is reinforced by our previous determination that the petitioners have established a prima facie case in the petitions before this court.
And I will handle the third issue, that is whether the conservatory orders in place should be confirmed. We reiterate that we dealt at length with the nature and principles for consideration in applications seeking conservatory orders. That was in ruling number 1, which we delivered some few days ago. We adopt that discussion as part of this ruling by a reference, and suffice to say that the three main principles for consideration are as follows. The first one being that the need for the applicant to demonstrate an arguable prima facie case. The second, whether the public interest will be served or prejudiced by a decision to exercise discretion to grant or deny a conservatory order. And the third is that whether, if an interim conservatory order is not granted, the petition or its substratum will be rendered nugatory. We will consider the set principles as they play out in this matter. On whether prima facie case has been demonstrated, this is a discussion which featured in ruling number 1, where we dealt with the definition and the nature of a prima facie case. We held that such is a case which, and I quote, "On the material presented to court, a tribunal properly directing itself will conclude that there exists a right which has apparently been infringed by the opposite party as to call for an explanation or rebuttal from the other," end of quote. See the case of Rao versus First American Bank of Kenya Limited and 2 others. In the said ruling number 1, we went further and said, I quote, "In sum, therefore, in determining whether a matter discloses a prima facie case, a court must look at the case as a whole. It must weigh, albeit preliminarily, the pleadings, the factual basis, the respective parties' positions, the remedies sought, and the law. In doing so, a court must be guided by Articles 22, Subarticle 1, and Article 258, Subarticle 1 of the Constitution, which provisions are on the right to institute court proceedings whenever a right or fundamental freedom in the Bill of Rights has been denied, violated, or infringed, or is threatened, or when the Constitution has been contravened or is strengthened with contravention, end of quote. Upon being satisfied, this court, in the said ruling number 1, rendered itself as follows. I quote again. Applying the above in this matter, and without much ado, we are satisfied that the consolidated petitions raise constitutional issues that require further judicial consideration, end of quote. This court has not deviated from the above position. We reaffirm that the consolidated petitions in cohort number 1 and in cohort number 2 still raise constitutional issues requiring further judicial interrogation. The second issue is whether with public interest considerations. Black's Law Dictionary describes public interest as the general welfare of a populace considered as warranting recognition and protection, something in which the public as a whole has stake, especially in something that justifies government regulation. In ruling number 1, we found and held that, quote, public interest tilts in favor of allowing the constitutional process to proceed unhindered, end of quote. To therefore understand how public interest factors into this matter, it is necessary to examine the historical context of the office of the now Deputy President. Naturally, the starting point is the retired 1963 Constitution, which hereinafter will be referring to as the 1963 Constitution. Chapter 2 of the 1963 Constitution addressed the executive, with part 1 thereof focusing on the president and the vice. Section 4 of the 1963 Constitution established the office of the president as follows, I quote, there shall be a president of Kenya who shall be the head of state and commander-in-chief of the armed forces of the republic, end of quote. Section 6 addressed a vacancy in the office of the president. And I may not go through all that, but it's in the ruling, you'll find it. Section 15 of the 1963 Constitution dealt with the office of the vice president. This one I will read. Section 15, subsection 1, reads as follows, I quote, there shall be a vice president of Kenya who shall be appointed by the president. Subsection 2, the president shall appoint the vice president from among the ministers who are elected members of National Assembly, provided that no appointment to the office of vice president shall be made at any time when the functions of the office of president are being exercised by any person other than the president. Subsection 3, the vice president shall be the principal assistant of the president in the discharge of his functions. We have emphasized that provision. Subsection 4, the vice president shall not enter upon the duties of his office unless he has taken and subscribed the oath of allegiance and such oath for the due execution of his office as may be prescribed by Parliament. 5, during his tenure of office, the vice president shall not hold any office of profit other than those of vice president, minister, and the member of National Assembly. Subsection 6, the office of the vice president shall become vacant if the president so directs. B, if the holder of the office ceases to be an elected member of the National Assembly, otherwise than by reason of the dissolution of Parliament, or C, upon the election of a person to the office of president. It follows that under the 1963 Constitution, the vice president served solely as the principal assistant to the president in the discharge of the presidential functions. The vice president had no other duties and could be dismissed by the president at will. After a lengthy and others 20-year pursuit for constitutional reforms, Kenyans ultimately adopted a new constitution in August 2010, which we'll be referring to as 2010 constitution just to distinguish it with the 1960 constitution. The 2010 constitution has been widely praised as transformative, particularly for its fundamental restructuring of the country's constitutional and governance framework. The 2010 constitution establishes the executive in chapter number 9. Article 131 outlines the authority of the president, while Article 132 details the functions of the president. Article 147 provides for the functions of the deputy president as follows. The deputy president shall be the principal assistant of the president and shall deputize for the president in the execution of the president's functions. 2, the deputy president shall perform the functions conferred by this constitution. We emphasize that. The deputy president shall perform the functions conferred by this constitution and any other functions of the president as the president may assign. Subject to Article 134, which deals with temporary incumbency, when the president is absent or is temporarily incapacitated, and during any other period that the president decides, the deputy president shall act as the president. And sub-article 4 says that the deputy president shall not hold any other state or public office. It is therefore beyond any peradventure that the role of the president's principal assistant changed significantly in the 2010 constitution compared to the position of the vice president under the 1963 constitution. Some of the notable changes include: 1, whereas the vice president was solely the principal assistant of the president, the deputy president is both the principal assistant of the president and also deputizes the president in execution of the president's functions. 2, the deputy president performs specific functions conferred by the Constitution. 3, the deputy president may perform any other functions of the president as the president may assign. 4, unlike the vice president who was appointed by the president from among cabinet ministers who are elected members of the National Assembly, the deputy president under the 2010 Constitution is elected together with the president and holds no other public office. The above changes were not without reason. In the book, The Constitution of Kenya, commentary by Louis and Pielo Lumumba, this is the second edition, Strathmore University Press, they are 2019 at page 453. The two eminent authors had this to say, and I quote: with the other arms of government considerably weakened, the executive personified in the president exercised unchecked powers. Indeed, during the constitutional review process, the CKRC noted that the powers granted by the Constitution and the ordinary laws to the elected president seemed to share characteristics with those of the colonial governor. It then resolved during the constitutional making process to divest some powers from the president with the aim of avoiding an imperial president, end of quote. The above cannot be far from the truth. In the pre-2010 constitutional era, the president held immense powers, including the ability to appoint and dismiss the vice president at will, and the discretion to assign or to withhold duties for the vice president. Consequently, the vice president served entirely at the president's mercy. That was the framework that the 2010 Constitution sought to transform. Under the 2010 Constitution, the office of the deputy president has been fundamentally redefined. it is now safeguarded from arbitrary and capricious actions by the president. Article 172 grants the deputy president specific constitutional functions in addition to any duties the president may assign. This provision was intended to address the previous situation in which a president could, for any reason, choose not to assign any duties to the deputy president, effectively sidelining them. Thanks to the 2010 Constitution, even if the president does not assign any additional duties, the deputy president still has specific constitutionally mandated functions to perform. In this way, the deputy president is no longer at the mercy and the discretion of the president. Under the current constitutional framework, when the office of the deputy president becomes vacant, two outcomes flow. First, any functions that were assigned to the deputy president by the president automatically reverts to the president. Second, the functions expressly conferred upon the deputy president by the Constitution do not revert to the president and cannot be performed by anyone else. This is a departure from the 1963 Constitution, under which the president could appoint a minister to act as vice president in the vice president's absence. The 2010 Constitution includes no such provision. Therefore, if the office of the deputy president is vacant, the specific constitutional functions assigned to that office remain unfulfilled. For clarity, not even the Speaker of the National Assembly may discharge the functions vested in the deputy president under Articles 147, Subarticle 2 of the Constitution. In light of the above, we are convinced and hereby find that the current constitutional framework does not envision any scenario in which the office of the deputy president will remain vacant, except during the brief period required to fill such a vacancy. Another equally important provision that adds credence to the above position, that the office of the deputy president cannot be left vacant, is Article 146(3) of the 2010 Constitution. However, before we interrogate the said provision, suffice to note that Article 150, Subarticle 2 of the Constitution, which is on the removal of the deputy president, has it that the provisions of Articles 144 and 145 relating to the removal of the president shall apply with the necessary modifications to the removal of the deputy president. Returning back to Article 146, which article deals with the vacancy in the office of the president. Sub-articles 1, 2, and 3 of that article provide that follows. These ones I'll read. Sub-article 1, the office of president, read deputy president, shall become vacant if the holder of the office A, dies, B, resigns, in writing addressed to the Speaker of the National Assembly, or otherwise ceases to hold office under Article 144, which deals with removal of president on grounds of incapacity, or Article 145, which deals with removal of president by impeachment, or under any other provision of the Constitution. Sub-article 2, when a vacancy occurs in the office of president or deputy, 1, the deputy president shall assume office as a president for the remainder of the term. 2, if the office of the deputy president is vacant or the deputy president is unable to assume the office of president, the Speaker of the National Assembly shall act as president, and an election to the office of president shall be held within 60 days after the vacancy arose in the office of president. Sub-article 3, a person who assumes the office of president under Clause 2A or following an election required by Clause 2B shall, unless otherwise removed from office under this Constitution, hold office until a newly elected president is sworn in following the next regularly scheduled election under Article 136, Sub-article 2A. End of Sub-article 3. Therefore, to us, a holistic reading of Article 146 alongside Article 152 of the 2010 Constitution, and in relation to the filling of a vacancy in the office of the deputy president in this matter, yields the meaning that the person who assumes the office after the impeachment of the deputy president shall, unless otherwise lawfully removed from this office, hold that office until further orders of this court or until the current term of the president ends, whichever comes first. The foregoing demonstrates that the structure of the Constitution, which reflects the popular will of Kenyan citizens, envisions a scenario in which the office of the Deputy President will always be filled except during the brief period required to fill the vacancy, as already stated above. Based on the foregoing, we now turn to the nature of the conservatory orders in this matter. It is widely accepted that the purpose of conservatory orders is to preserve the status quo pending further orders of this court. The Supreme Court in Gatirao Peter Munya and Dixon Mwenda Githinji and two others said as much. In this case, maintaining the status quo would mean, one, that the first petitioner remains impeached under Article 145, sub-Article 7, which affirms the finality of the impeachment process with the following provision, I quote, if at least 2/3 of all members of Senate vote to uphold an impeachment charge, the Deputy President shall cease to hold office, end of quote. Two, additionally, the prevailing status quo will mean that the Deputy President nominee, Professor Abraham Kithure Kindiki, does not assume office. With such an approach, while such an approach may seem fair, reasonable, and balanced, and one which this court would ordinarily be inclined to adopt, the unique nature of the Deputy President role under the 2010 Constitution suggests a different course. Allowing these orders to stand will leave the office of the Deputy President vacant. The problem, however, is that no other person is authorized to carry out the constitutional functions specifically assigned to the Deputy President under Article 147, sub-Article 2, once those assigned by the President revert to the President in the absence of an office holder. The result would be a de facto suspension of Article 147(2) of the Constitution, an outcome that no court should knowingly permit. For clarity, this court firmly holds that no court should issue orders that have the effect of suspending the operation of any provision of the Constitution, such an outcome is clearly not envisioned by the document itself. The Constitution was not handed to Kenyans on a silver platter. No, it was achieved through great struggle and sacrifice. Therefore, it is the duty of the court to uphold its provisions as intended by the framers and as demanded by the people of Kenya. Furthermore, Article 259 of the Constitution mandates that the document must be interpreted as always speaking. This means the Constitution is a living document designed to address contemporary challenges and to be applied consistently and continuously without interruption. Suspending any provision of the Constitution, even temporarily, would undermine this principle by creating gaps in its operation and disrupting the intended balance of governance. The Constitution is structured to ensure that all its provisions are effective and operative at all times. If any provision, such as Article 147, sub-Article 2, is rendered dormant by a judicial order, it risks setting a precedent where parts of the Constitution could be selectively switched off, effectively weakening the Constitution's authority and the protections it affords. Additionally, we are mindful that courts are guided by the principle of constitutional supremacy, which requires that all judicial decisions align with the Constitution's objective and upholds its integrity. Issuing an order that suspends a constitutional provision would directly contravene this principle, effectively placing judicial discretion above the supreme law of the land. This will be inconsistent with the spirit of judicial restraint and the court's role as a protector and not a modifier of the Constitution. For these reasons, we take the position that the Constitution must remain fully operational at all times and no court order should have the effect of rendering any part of it inoperative or dormant. The court's responsibility is to interpret and apply the Constitution as a cohesive functional document that serves the people's enduring will and protects the structure of governance as established. Drawing from the above, we hereby find and hold that public interest in this matter favors giving way to the Constitution, which in any event is the will of the people. That is also the dictate under Article 3 of the Constitution, where every person has an obligation to respect, uphold, and defend the Constitution. We choose to abide by that calling. As such, public interest demands that the office of the Deputy President should not remain vacant. Whether the consolidated petitions will be rendered benefitory in the absence of any orders. As we stated in ruling number 1, because the consolidated petitions challenge the entire impeachment process, the fundamental issues at stake remain live, even though the parliamentary proceedings have been completed. Furthermore, as previously noted, should any of these petitions succeed, this court will have no shortage of effective remedies to address the situation. The next issue is whether the applicants will be prejudiced if the orders are not granted. Regarding whether the applicants will suffer any harm if the conservatory orders are not granted, we find that no individual can suffer loss or damage when the Constitution is permitted to operate as intended. Allowing the constitutional process to unfold does not in itself result in detriment, as it upholds the rule of law and respects the framework agreed upon the people. The applicants also urge the court to grant the conservatory orders, expressing concern that the respondents have a history of disobeying court orders, and that once the office of the Deputy President is filled, it will be impossible to remove the appointee, even if the petitions were successful. However, this court takes the view that it cannot operate under the assumption that its orders will be disregarded. This country has legal mechanisms to address any acts of disobedience of court orders. Moreover, the Honorable Attorney General, through Senior Learned Counsel, Professor Getu Mugai, has given an undertaking to comply fully with any orders which will be issued by this court in this matter. As such, we find that the applicants do not stand to suffer any prejudice in the event the conservatory orders are not granted.
This position, as we conclude, we reiterate that this matter holds significant public interest, and we remain committed to an expeditious examination of the petitions. Therefore, we will further provide directions within this ruling. Consequently, the following orders are hereby issued. 1, the applications for conservatory orders are hereby allowed. 2, the conservatory orders issued on 18th of October 2024 in Keregoya High Court E015/2024 are hereby discharged and or set aside. Costs of these applications shall be incurred. We grant leave for appeal, type proceedings, and certified copies of this ruling to be availed to parties at cost or as it may be. We will mention this matter on 7th of November 2024 at 2 p.m. in the open court. This ruling shall forthwith be uploaded in the court tracking system. That is the ruling of the court.
Most obliged, my lord, and I have an
much obliged, my lord. We want to take this opportunity to thank your lordships for the time that you have taken and the judiciousness with which you have expedited the applications. And I also want to thank my colleagues from the respondent side and from the applicant side for the maturity with which this matter has been handled. We are most grateful, my lord.
Thank you.
My lord, my name is Ochiel Dudley for the Deputy President, and I wish to make an application. The application I wish to make is called the Madhu Pepper Injunction. Madhu Pepper International, quite a famous case. In the common law, it's called the Erin Ford Injunction. My Lord, the Mother Paper injunction operates on quite a simple premise, the premise of human fallibility. In the case of Erin Ford, where that injunction originates, Justice Megari, after dismissing an application for injunction like you have now, found still that there could be the slightest chance that he was wrong. Here, there could be the slightest chance that you're wrong. Last week, this court gave the Deputy President leave to appeal. We thank the court for that generosity. The Deputy President has appealed. He also has pending before the Court of Appeal an application for stay of these proceedings, and that application comes up on the 6th of November 2024. My Lord, operating on the premise of human fallibility, the foundation of the Erin Ford or Madu Paper injunction, we request you to recognize that you could be wrong. And if you're wrong, then the pending proceedings before the Court of Appeal would be rendered nugatory. To avoid that possibility, the possibility that the Deputy President's right to appeal, which you recognized and affirmed and upheld by giving him leave to appeal, even where he needed none, we ask you to issue a Madu Paper injunction. We do not seek an indefinite injunction. We seek an injunction until 6th of November 2024, when we are next before the Court of Appeal. Thank you, my Lord.
My Lord, we also have a moment to bite the cherry.
The black bull, okay.
Yeah. My lords, I want to associate myself with the submissions made by my learned friend, and also state that I have listened keenly to the ruling that has been delivered by this honorable court. While we largely disagree with it and we have a right of appeal, Your Lordship, it is imperative for us to know or to assess how that office of the Deputy President will be filled. This court has affirmed its commitment to observe the rule of law and protect the Constitution as decreed under Article 3 of the Constitution. It follows, therefore, Your Lordship, my ladies, that the filling of that vacancy must flow or must follow the Constitution. And as such, Your Lordship, and as much as I have not heard the court address that very pertinent issue, it is my submission, Your Lordship, that I rise under Rule 23. Beg your pardon. Rule 23 and Rule 24 of the Mutunga Rules. And I make an application, Your Lordship, that pending the determination of this application, done under Rule 24, that this honorable court does issue conservatory orders suspending the swearing in of Professor Kithure Kindiki on the following grounds. Your Lordship, Article 10 of this Constitution, of the Constitution, bids this honorable court to observe the rule of law. It further calls upon this honorable court to commit itself to ensure that there is good governance, there is accountability and transparency in the manner in which matters are done or functions are executed.
My Lord, with your kind permission,
it's an
Mr. Jero has referred to an application for which he's seeking some orders pending, but we haven't seen any application in that regard.
Yes, Your Lordship, if Mr. Kamotho was keen to read the rules, the Mutunga rules allows me to move you informally. And subsequent to me making an application informally, the court is called upon to reduce the same into a formal application. And that, Your Lordship, I want to draw his attention to Rule 24, Sub-Rule 1. An application under Rule 23 may be made by way of notice of motion or by an informal document. Your Lordship, permit me to proceed with the grounds of my application. It is clear, Your Lordship, that the court...
My Lord, if I may, I respect my learned friends. My Lord, I respect... Yes, I respect Mr. Njiru. He's referring to an application that is non-existent. Either is referring to E554. Mr. Kamina, sit down. E554 of 2024, which is before the Court of Appeal, if you are referring to that application. But my Lord, if my learned friend is referring to the exercise of this court of epistolary jurisdiction, then he should say so. But he cannot refer to the exercise of that jurisdiction, my Lord, when this court is functus officio. You have rendered yourself on the question of the application. And therefore, they cannot urge an application unless they say, my Lord, number one, is either served on us, or two, my Lord, because there's already an application for stay under Section 5 to